Good afternoon and welcome to the University of Georgia School of Law. My name is Beau Rutledge and I'm the Dean of the Law School, and it's my honor to welcome you all to the 116th Sibley Lecture to be delivered today by Yale Law School Dean Heather Gerken. At the University of Georgia School of Law, our commitment is to produce world-class ideas, to provide first-rate legal training in service to state and society, or as embodied in our mission to prepare, to connect, and to lead. And today's lecture embodies that mission. In 1964, the trustees of the Charles Lorden's Foundation established the Sibley Lecture series in tribute to a great leader, the late John A. Sibley, a 1911 graduate of this law school whose portrait adorns our walls. I would like to take a moment to recognize Mr. Bob Edge and Mr. Harvey Hill, trustees of the foundation, who join us today for their generous, constant, and loyal support of the law school and this lecture. This series honors the legacy of leadership and service that John Sibley embodied over the course of nearly 80 years of commitment to the state of Georgia. Since its creation over 50 years ago, the Sibley Lecture Series has attracted outstanding speakers. The first lecture was given by Yale Law School's Professor Myers McDougall, focusing on the topic of jurisprudence in a free society. Indeed, in preparing my remarks, I was looking at the law school webpage on prior Sibley Lecture speakers and did that little find command where I started to type in the word Yale and lost count. Since the law school hosted Professor McDougall over 50 years ago, other influential speakers who have delivered this lecture include United States presidents, Supreme Court justices, distinguished members of the judiciary, solicitors general, and renowned academics from around the world. Joining their ranks is today's speaker, Dean Heather Gerken, who once again travels from New Haven to Athens to strengthen the relationship between our two law schools. Dean Gerken joined the Yale Law faculty in 2006 and was named Dean in 2017. Congratulations. She also served as the Saul and Lillian Goldman Professor of Law at Yale and is here today to deliver her lecture, The Lessons of Lawyering, Why Ours is an Honorable Profession. Dean Gerken's scholarship focuses on issues of federalism, diversity, and dissent. She is one of the country's leading experts on constitutional and election law, having published in the Harvard, Yale, and Stanford Law Reviews, and whose own work has been the subject of at least 4 different symposia at law schools. Dean Gerken's work has been featured in the New York Times, The Atlantic, the Boston Globe, and Politico magazine recently named her one of the top 50 idea makers in American politics. She has served as a commentator for NPR, CNN, MSNBC, and NBC News. She received her law degree summa cum laude from the University of Michigan Law School and her undergraduate degree from Princeton University. After law school, she clerked for the late Judge Stephen Reinhart and U.S. Supreme Court Justice David Souter. She worked as an appellate lawyer in Washington, D.C., before joining the faculty of Harvard and later moving to Yale, where over the course of her career, she's won teaching awards at both universities and was honored as one of the nation's 26 best law teachers in a book by Harvard University Press. It is my honor to introduce you to you, Dean Heather Gerken.
It really is an extraordinary honor to be delivering this lecture, so I want to say thank you first for that, and thank you to the entire University of Georgia community. The Yale-Georgia connection is deep. I believe your founder, in fact, was an Eli, and of course, we all share a deep and abiding love for Bulldogs. I also want to thank Dean Rutledge and also, of course, Professor Birch, who have been extraordinary hosts and have given the hospitality to the phrase Southern hospitality, and to acknowledge the Charles Loridans Foundation and, of course, our Yale Law School graduates here in the audience today. In the spirit of John Sibley, I want to talk about two of the values that I think run deep in our profession and make ours an honorable profession. I want to talk about those values, why they matter, and how they are salient to politics today. So I believe, and I know many of you in this room agree, that lawyering is in fact a noble profession. That is not our profession's reputation. I suspect every one of you has had to endure lawyer jokes from basically the day that you arrived on this campus. To many, we are the consummate hired guns. People look to lawyers and they see an industry of arguments for hire, a guild of professionals willing to promote any and all causes as long as the price is right. But this is not an accurate picture of what we do. Lawyering is an honorable profession. It is not one of mercenary zeal. Lawyers may seem like they stand for nothing because we are trained to know how to muster an argument for any side. But in fact, lawyers always stand up for what is most important. We are the keepers of an essential pillar of any civilized society. We are the keepers of the rule of law, the building blocks of democracy. And today I want to talk about how those seemingly contradictory ideas fit together. How it is that a professional tribe taught to argue about everything still manages to believe in something, the rule of law. That is the first most important lesson I think our profession has to teach. Now, if you want proof of the important role that lawyers play in defending the rule of law, you just need to read the newspaper. Look at what is happening in Egypt, in Pakistan, in Guatemala, in France. When countries slide into, in Turkey, when countries slide into authoritarianism, you will always see lawyers, the people supposedly taught to believe nothing, the people who are taught to argue for on the other side. You will see those lawyers standing up for voting rights, for due process, for integrity in government, and for equality under the law. So how is it that members of a profession taught to doubt are the ones who put their bodies on the line for what they believe? It starts with our training. The kind of training that we receive in law school, the kind of training that the students in this room received right here in Athens, how law schools throughout the country teach. Law school conditions soon-to-be lawyers to know the difference between righteousness and self-righteousness. We don't just teach our students to know the weaknesses in their own arguments, we demand that they imaginatively and sympathetically reconstruct the arguments on the other side. All of you know this painful experience, that first semester of law school, when over and over again, from the first day in class, you as a student are forced to argue for a position in which you don't believe and to make the best case for a side that you dislike. Every law professor I know always tees up a case where she's completely sympathetic to one side, the side that wins, and then brutally dismantles that reasoning. We teach students that even the grandest principles have limits. To my mind, the day that you become a lawyer is the day that you realize that the law does not and should not mirror every single thing that you believe as a person. We try to develop enough distance from our own commitments to recognize what is honorable in the commitments of those on the other side. We train ourselves to check ourselves habitually, almost reflexively, because the legal system is premised on the hope that truth will emerge if we ensure that everyone has a chance to have their say. And out of this rule, we believe, comes truth. So lawyers, in short, are taught to see the world not just through their own eyes, but through the eyes of their opponent, and nothing is more humbling than that. Now, once we learn these important tenets, what do? We spend all of our days savaging arguments. We lay waste to the worst ones. We whittle and whittle away at every last shred of sense in the best ones. We break down every proof, every argument, every theory. We challenge claims, rework them, we build them up and then strike them down at their foundation so that they topple like so many bricks. Now that makes us annoying to people who are outside of the law, because all we do is be critical. And they think that all we do is, all we're involved in is in decimation. But what they miss is what I think of as a peculiar alchemy in the rigor that lawyers apply in their arguments. Because after this brutal process of dismantling, this process of creative destruction, what remains is as strong as steel. What remains are the values that many lawyers are willing to die for. What remains is what we affectionately call the rule of law. A terrific scholar and one of my predecessors as dean of Yale Law School, Tony Kronman, has said it to me, I think, most succinctly when I spoke with him earlier this year. He said, "We defend the values where there is no argument on the other side. They are unimpeachable. They have survived generations of lawyers trying to take them apart, who have subjected them to the most grueling intellectual scrutiny each and every day." And I think this lecture series is really a testament to those values. Since its inception over a half century ago, lawyers and academics of the highest caliber have come onto this stage to talk about the rule of law. There was Ruth Bader Ginsburg, who continues to be an outspoken defender of equal rights. Bryan Stevenson, who is breathing life into how justice is administered. And the great Earl Warren, who struck some of the strongest blows for racial equality during his time on the Supreme Court. Ultimately, this forum is a forum for talking about the rule of law. It is for those of us who believe in certain unimpeachable ideas to share them, to put them forward, and to subject them to question. And it's a series, I think, that speaks volumes about the profession's integrity and its unifying beliefs. Now, defending the rule of law feels also personal to me for two reasons. One is a small one, but I think everyone in the last 13 months has watched as lawyers have stood up in this country to defend the rule of law. And to my mind, the most vivid moment is a story I told to some of our alumni last night. The most vivid moment was that moment when the travel ban was put in place. And lawyers throughout the country just went to the airports to help people who were in need. What makes that story quite personal for me is that the lawyers at those airports were relying on a case that our students won and the templates that our students wrote. Because you see, like this law school, we have also trained a generation of lawyers to defend the rule of law. And the reason why our students were involved was very simple. One of our lawyers had been working with refugees for a long time. Her client was named Darwish. On the night of the travel ban, she called up her old professor who was coming out of a Celtics game and said, "Mike, I have a client who's stuck at the airport in the travel ban." And within a few hours, our students had created a war room. Every lawyer in the country was asleep, except for our students. They set up a war room, they pulled an all-nighter. Within 12 hours, they filed a nationwide class action in federal court. Within another 12 hours, they had won a nationwide injunction. After that injunction was put in place, those students then began to think about all the lawyers across the country who needed help. So they wrote templates so that lawyers who weren't immigration lawyers would know what to do. And those templates were passed from iPhone to iPhone and from iPad to iPad. I actually met one of our grads who said, I was at the airport and I received one of those templates. And when the names of clients were being passed out to the lawyers at JFK, the name that I got was one of my classmates at Yale, an Iranian LLM. And she used that case as he was right in the room next door, texting with his wife. She used that case to free him. The most fabulous moment for us came when one of our first-year law students who was working in this clinic discovered that although the Department of Homeland Security had said that the injunction was being obeyed, in fact it was not. And that one of our clients was actually about to be deported, was on a plane on the tarmac at JFK. And just imagine for a second, for those of you who are law students, here is a student, his first year, his second semester, 2 weeks in. And he called air traffic control. He put on what his supervisors refer to as big lawyer voice. And he explained to air traffic control that his client was about to be deported and actually pulled the plane back off the tarmac. So those students were taking up the grand tradition in the rule of law. Those students were doing what we teach them to do and what we hope they will do. Those students are doing what we expect all of you to do, which is to defend the rule of law as always been a tradition in our tribe. I'll say the other reason that this feels close to me especially is because like Professor Ringhan, I'm an election lawyer, and you can't be an election lawyer and not care about the rule of law, because in the centerpiece of the rule of law is a right to vote. There is no substitute for it. Without the franchise, we are voiceless. And that is why lawyers have always flocked to efforts to achieve and protect the right to vote. Because lawyers, I think, see their own professional creed, their own enduring values reflected in movements to protect the right to vote, reflected in the cries of suffragettes, in the hymnals of Southern Baptist preachers, and in the chants of activists. Now, rule of law values are nonpartisan. They reach across party lines and apply to all of us. They also stretch back in time because they are enduring. They stretch back to the first Marshall Court, and they run straight through the current Roberts Court, and the Georgia Supreme Court, which I understand once held a special session in this beautiful room. Rule of law values are the claims for which everyone in this profession who are trained to identify every counter-argument exists cannot find a counter-argument. They are the steel that remains when there is no argument on the other side. And they are the chain that links generations of lawyers together. So to my mind, that is one important lesson of lawyering, the reason why those trained to argue about everything nonetheless believe in something. Now, there's another value I think of that is highly relevant to today's politics that is also deep inside our profession, and it is entirely related to the first one and just as salient to this political moment. Lawyers know how to go to war without turning the other side into an enemy. And that lesson also comes from our training, because you cannot be a lawyer. You cannot be a lawyer without knowing the best arguments on the other side and the worst flaws in your own. And that is as humbling an experience as it can be, because it teaches us not to demonize the other side, but to recognize what is honorable in the commitments of the people that we oppose, and to recognize the weaknesses in our own commitments. And seeing that sort of fundamental humanity in our opponents, empathizing with their worldview, trying to see the world through their eyes, that is a lawyerly virtue. Once upon a time, it was also a political virtue. And I know that because I remember so vividly in 2008, I was working in the Obama boiler room. I was one of his senior advisors. And it had been a long day. We'd been there since 4 a.m. We were covered in industrial dust because the Obama campaign was so cheap they hadn't even bothered to clean the rooms. It was a hectic day. At the very end of the day, they bussed all the staff to Grant Park, where the staff was going to watch the president accept the presidency. And just as we arrived, behind us were hundreds of thousands of people who'd been waiting all day to watch the first African American accept the presidency. And as we came in and were sort of gathering around, the jumbotrons lit up, and there was John McCain delivering his concession speech. And I'll tell you, the crowds behind us were jeering and booing and so on. And I don't want to suggest that there was any love lost between the Obama and the McCain campaign, but nonetheless, the entire staff stood at attention, completely silent and respectful as John McCain delivered that speech. I'll always remember it. It was like watching one army surrender to another. That is also a lawyerly virtue, and once used to be a political virtue. And I will say that it's a kind of virtue that we need at this moment, because even as we do political battle, it's essential that we respect the other side. Politics needs it. Governance demands it. We need some mutual respect, because otherwise negotiating and compromise are impossible. And negotiation and compromise are essential for us to move forward. Otherwise, governance can't occur. So we can make arguments. We can fight tooth and nail for what we believe is right. But we have to still recognize the honor and the commitments of the other side and agree on some fundamental and unbreachable ideas. So I don't want to suggest we aren't in a fight for our national values. I think we are in the midst of just that kind of fight. And politics is where that battle is being fought. So I do think we should fight, and fight hard for what we believe in. But we should fight in the fashion that our profession teaches us to fight. Because even as we do battle, we must recognize the best in the other side and the worst in our own. That's what it means to be a lawyer. So I'll just close by noting what I think of as one more challenge to our democracy, and it also strikes me as one that universities in particular and law schools specifically are best able to negotiate, and that is the attack these days on truth. Truth, expertise, and evidence are all under attack these days. The slide from truth to truthiness has been lightning quick. And the question that we have to think about is, what are we going to do about that as a university where we argue about everything, but still have values, and as lawyers? How are we going to think about the problem of truth in this society? Because even if we disagree about many, many things, it has to be true that we can work from a common set of facts. You can go in any direction you want with policy, but the facts have to be agreed on. And again, I don't think this is a partisan point any more than rule of law is partisan. Rule of law values, like truth, they know no flag, they know no emblem, they know no ownership, they don't have a headquarters in DC. They belong to all of us, and they exclude no one. But somehow, as we fight over something that's fundamental to our values these days, we also find ourselves doing value about what is truth, what are facts, what constitute evidence. In fact, I think it's because the fight over our values has become so fierce that truth has been belittled. And here again, I just want to turn to the values of our profession, because we are a profession that fights about facts, that fights about what the truth is. But at the end of the day, we believe that truth exists. We are trained to negotiate just the kind of contradictions that our politics present for us now. Now, we're not the only ones. I'll just note that this is, again, a deep part of our tradition, so I'll invoke another lawyer, John Adams, the great Bostonian statesman. He once said, long time ago, that facts are stubborn things, and whatever may be our wishes, our inclinations, or the dictates of our passions, they cannot alter the state of facts and evidence. Now, I'll note for you that John Adams uttered that from a courtroom floor. He was representing a unit of 5 British soldiers who had killed people in the streets of Boston. It had been a massacre, and it was the Boston residents were out for blood. The British soldiers who murdered those 5 people were about to be hung, probably by a mob. But Adams, the leader of the nascent resistance that would become our revolution against the British, stepped into the breach and volunteered to represent those soldiers in court. He was scorned for this decision. He was called a traitor by the very people with whom he ultimately fought. But Adams insisted that the dictates of passion and politics cannot and should not smother evidence, facts, and truth. Now, in the end, thanks to Adams, the soldiers were acquitted, and the rest, as they say, is history. But Adams was right, and he should be our model. Facts are stubborn things, and we should stand up for them, even if every bone in our body pleads us to remain silent. Now, these days, pleading for facts might sound like a call to resistance, but when a call to reason is understood as a call to resistance, that only confirms the sorry state of our politics. So lawyers, to my mind, are the people that our politics need now because of the values we hold. Lawyers are the few remaining people who know how to question everything and simultaneously dig in our heels and stand for truth. We are the profession that believes that everyone has a right to speak and to be heard. But afterwards, we also believe there's a conclusion to be found, a right answer to be had, and that right answer must be respected. Now is the time to protect those values. We should insist on truth and its importance even when it's uncomfortable. Just as our profession, trained not to believe in anything, has long stood up for the rule of law, so too should we remind the world that even if we disagree all the time about truth, we all should still believe in it. Facts are stubborn things, and so are we. Thank you very much. So I know it's a tradition for this lecture to take some questions, and I should just note, I'm happy to take questions on anything, although not anything. I once made that offer to my constitutional law class, and one of them asked if he should date inside his section. So, but I do, the things that I'm talking about here are dear to my heart, not just because I'm an election law professor, but because I study federalism. And I had this worry that at the moment when I became dean and stopped writing scholarship, that my two fields are falling apart. And the reason they're falling apart is because both federalism and election law depend on politics to work in some way. They facilitate politics, but they also depend on it to work. And I worry that at this time of deep polarization, we're seeing the end of the two fields that I love the most. So please, I'm happy to take questions. And I'm also happy to cold call. I'll say, you can ask my students. Go ahead. No, it's exactly the right question, and it's beautifully stated because it really gets to that deep tension. If you call something truth, right, you put it off away from the ability to argue about it. And I'll just tell you that when I look at what universities are doing at this moment in time, they are struggling with this. Because if you are a scholar, you never call something truth in a public setting. Why? It would be unscholarly, right? Because if you call something truth, you say it can't be debated, and of course we debate everything. And in some ways we're whipsawed by both the right and the left in this respect, because if we let something be debated, even if it is a deep and core value, some people will take it to mean that you don't really believe in the value at all. So that the universities are trying to find this middle ground between, on the one hand, worrying about labeling something truth, because if you do so, you put it off of debate, and on the other hand, worrying that by leaving something to debate, which is at our core, that you're somehow suggesting that it's not true. And so I think that's to me why lawyers, oddly enough, are really the ones who should be looked to in thinking about this problem, because we have always managed that tension. And when I think about how we manage that tension, we don't manage it magically. There's no perfect fix. But what we do is relentlessly train ourselves to know the difference between our own impulses and the good argument. I will say I always teach a case on state action in my class. It's a voting rights case. I'm sure you teach. It's the white primary cases. And at the very last of the white primary cases, there's a case where the Supreme Court does justice. It helps African Americans who've been trying to vote in Texas for years, allows them to vote. But the grounds on which it rests is a state action direction, which is, I think, baseless. So I give the case to the students and I say to them, who thinks that this was rightly decided? And they all raise their hand because they have good hearts. And then I challenge them to a duel. I stop being a professor, I go into lawyer mode, and I decimate every argument that they give me. I've challenged election law and common law causes to a duel every year. Not one of them has come up with an argument that holds water. And then at the end, I say to them, okay, now what do you think? Now, they're law students, right? So not all of them see, but they start to realize the difference between what you think is right and a good argument. And I think that's what our profession trains us to do all the time. We're not perfect at it, but we try harder than anyone else I can think of. I think of that as a value of a good scholar, and I think that's the only solution to the problem you describe, which is to relentlessly question ourselves and to be sure, really sure, that there is no argument on the other side. Yeah. Well, I want to separate out two pieces of it. So there are the things that we do inside the process, which is based on the faith that if both sides do their best argument, that the process will lead to truth. So the one about doing your best to undermine the argument of someone you think is credible, that's not a story about bad lawyering. That's a story about arrogance and also sort of defending a client and a set of values. So that to me is well within the ambit of what lawyers do. My colleague Daniel Markovitz says that lawyers are taught to lie, cheat, and steal. I don't take that view. But what he says about lawyers inside the process is that what they are doing is telling another person's story in as powerful ways that they can. They're giving voice to everyone. And that is a noble process, even if there are pieces of it that are ugly and not fun. I was a litigator too, and I remember the day where I was working for the forces of good and light, and I went through a deposition and tore apart the other side, and I felt it was a nice person on the other side. I went home and took a shower, had a drink, and wondered whether I should be a litigator anymore. But I also, that's internal to the process, and I think that's a different kind of question. I don't mean to say there aren't bad lawyers. I don't want to argue about the particular ones that you're describing. It's not like we don't fail and fail often, but I don't think that those are the values of the profession. And I think that over time our profession has withstood that test. And it really came to me, this is when it came to me, I'm a cynical law professor too. And boy, I think my job is always to teach my students to doubt and to question everything and to avoid any starry-eyed views of everything. And then I went to Turkey for a rule of law conference right before Erdogan really cracked down. And what struck me is these basic values that I'm constantly nattering about with my students and picking and attacking and trying to blow up any starry-eyed view that they might have. There are these lawyers who are putting themselves on the line who said before the conference that they weren't sure if it was going to get shut down or not, and make sure we had our US passports to protect us if it did. They were defending these basic values, and they cared about these basic values. And when you ask them why they were doing it because they wanted to ensure the core values of a democracy and the core values of the profession. And that reminded me that we get cynical pretty quickly when these things are not at risk. But when they're at risk, lawyers are look at Pakistan, look at Turkey. Those are the ones who are standing up for it. So I am willing to cede bad lawyering and that we fail. But I do think that if you ask any lawyer what are the values of the profession, they would articulate those. And I have faith in that profession. Yeah, so I will say I'll just draw a distinction between the rule of law and law. So anything can be instantiated in a law. Nazi Germany instantiated a lot of what it was doing into a law. One of the things about watching Turkey, Erdogan did a lot of what he did through completely lawful and even democratic processes. So that's where I want to draw the distinction between the rule of law, these core values that stretch across time, and law itself, because law can be a weapon and a shield in this respect, and can be used by those in power or by those who are powerless. And so I want to separate those two things out, because law is it can be a fearsome and terrible tool of destruction. But the rule of law, those values that undergird it, those I think are quite different. Those are the ones that stand up to the test of time. And I'll just say, my test for the rule of law is always, is there an argument on the other side? For those pieces of law that you're describing, there's always an argument on the other side. The better argument is on the other side. But for the kinds of things that lawyers have sort of settled on as rule of law values, it's much harder to make those arguments. So for those of you who couldn't hear, and it's so nice to have the students taking part, it's a very good sign about a law school. What are the things that I'd like to see changed in the? That's a great question. So one of the things I think we actually don't do enough in this cynical age is talk a little bit about our history. This goes back to the earlier question. Law professors are the worst cynics ever. I think election lawyers are the cynics of the cynics. We sort of pride ourselves on not believing in anything, and so sometimes I think actually it's useful to go back to the basis and to talk about the heroic pieces of our history as well as the ones that are not heroic. So I would like law schools to do that more often. I'll just say, as a school that has always been known for being theoretically ambitious, I actually think that one of the best things that's happened to my law school in the last 10 years has been that we have become as ambitious on the practice side as the theory side. And the reason why that matters is, I just described to you these extraordinary students that won this nationwide injunction. They were back in federal court again, defending the DACA litigation. You may have noticed in Brooklyn, the lawyers looked kind of young. They were second and third year law students. There's a moment when the New York Attorney General turned and said, well, I think that Ms. Schoen should answer that question. Ms. Schoen was a second year law student who'd been in my con law small group the year before, and there she was arguing this case, winning another nationwide injunction. Those clinics, whether the clinics that win nationwide injunctions or the clinics that engage in individual relief, are also a place where you learn about the values of the profession, where you take all of the sort of abstract things you learn in school and you put them into practice and refine them and think harder about them. And I think that there's been a way in which clinical education has been downplayed in the by the legal academy in a way that I think is foolish. I have been a clinician for more than a decade. Even though I'm at Yale, I know you can make the Yale jokes. Anything law schools can do, Yale can do meta. We teach not contracts. There's all this sort of stuff about it. It drives me crazy. But I think there's something magical about being completely ambitious about theory and ethics and institutions and all the problems that lawyers think about inside their classes. and then being just as ambitious on the practice side and seeing in the real world how those values translate. So if I were saying to your generation, I would say to you, make that the model. And I just want to be clear, it is not a trade-off between practice and theory. It's not elevating practice above theory or theory above practice. It's recognizing that they're inherently intertwined. And that if you think about ethics and morals and the way an institution should work, you should be doing both at the highest level. That is what it means, to, since Holmes was quoted, to live greatly in the law. So if I were your generation, I would actually go and talk to your bars and say, look, if you're worried about students being practice ready, don't impose another 6-hour experiential learning requirement or some paperwork for an administrative dean to do. Have them create clinics where students get to do real-world work that's as ambitious and as great as the students themselves. That is how you also learn ethics and learn the values of the profession, and I'd like to see that model reproduced.
You mentioned.
Ha! It's a good question. Everyone thinks of their parent at this moment. You know, it is really hard because now even sort of the invocation of expertise is thought to be a political move. And I think that you just have to call that out every single time because I think the problem is we've allowed that to happen. And I think that we did not take it seriously enough when it happened because we just sort of thought, I think legal academics in particular, of course expertise is valued, of course it matters. And now to discover that that's slipping away so quickly, becoming parts of the wind, you know, torn apart by the winds of polarization, you have to defend that right away. And if you don't defend that, then there's really no hope of it. So I think a part of it is not just agreeing on a set of facts, because that's hard, but calling it out as political, calling it out as something that you shouldn't do and can't do. And we have not done enough of that, I think. Universities in particular, you know, universities, they've always put themselves a little bit on the sidelines with good reason. Right? They've always been on the sidelines because they want to be sheltered from the world, to have a little bit of objectivity, not to be in the maw of politics. That's always been our approach. It's not working, right? We are in politics. We have been politicized. And if we don't step up and defend what are our core values and call out these kinds of things, then I think there's very little hope for universities to play a substantial role, and for law schools in particular to play a substantial role in politics going forward. So I don't want to suggest it's easy. Although I do think, for what it's worth for your generation, don't do it online. A face-to-face conversation is always going to work better. You know, my daughter is 16, and you know, nothing happens face-to-face these days, even when they're with each other. So I'll just say, for what it's worth, I do think face-to-face conversations are the right way to start those conversations. So that was a far better answer than the one I just gave, so I really appreciate the amendment, but that seems exactly right to me. It particularly seems right when I think about election law, because to the extent that we ring the alarm bell over and over and undermine people's faith in democracy, we are undermining their ability to govern going forward. And so, you know, I've been hyper careful about ever since Bush v. Gore, perhaps earlier than that, but that's when I was a young election lawyer, there have been crazy conspiracies on the left and on the right about elections, and I am always hyper careful to tamp them down and to be very careful about those things for exactly the reason you described, which is, right, if you eviscerate the institutions for too long, then you're going to lose ground. And in some ways, again, that's a value of the profession, right? So lawyers will go into court, they'll make all the arguments and do all the sort of distasteful things that we were just talking about. But at the end of the day, when the verdict comes down, the verdict stands. Lawyers walk from it. They're very careful about not criticizing the court in a fashion that is terrible. I mean, it's interesting to see. This is about the norms eroding. It's gonna be interesting to see how robust they are at a time when they're being challenged everywhere. Because I think you're exactly right. When I'm very influenced by the work of Jack Goldsmith, and Jack talks a lot in his work about the way that norms, powerful norms, actually restrict presidential authority far more than law. And the question is, how long will that go? I think about that in federalism too. So federalism depends on you not thinking the other side is a monster. Because if you think the other side is a monster, you will never allow them to vary from the rule that you want. So federalism only works with a little bit of give and take, a little bit of respect, begrudging respect for the opponent. So I think what you just described is true in every field that I work in, and is true generally, and I'm really worried about it too. So then going back to the student, so be nice to institutions, be respectful of them. That's a great question. For those of you who couldn't hear, it's where do the rule of law values come from? I do think, wouldn't say they come from tradition, but tradition is one signal that they exist. One of the things I love about lawyers is that we are so methodologically eclectic when we think about these things, because when you think about the rule of law, it's a value, right? So something about what's in your gut. It's about tradition. It's about fit, and whether it fits in as a plausible way of conducting society. We engage in constant questioning about how it applies in an individual situation and disagree about that. We test it over time. It frustrates other disciplines. So if you're a philosopher, right, you start at a certain level of abstraction and you work your way through it, and then you have proof. And lawyers are so messy because they refer to lots of different sources for things like the rule of law, just as they do for developing doctrine. Whenever I talk to people in other disciplines about these things, I always say, lawyers want to give you a map. And they're not just going to give you a map that's just going to show the geography of the place you're looking at. They're going to show you the topography. They're going to overlay the population. They're going to tell you about where the crops are grown. And it's true that it's not as clean or neat or clear as the identification of one source for law or one source for the rule of law, but you also get a much richer view of it. And you can be sure of your conclusions because you have so many more pieces to put together. So I think of it as something that is derived not just from one thing like tradition, but that tradition is certainly an important part of it. Thank you very much.